Hello, everyone. Today we are going to discuss paper one for patent agent examination that was conducted in 2018. In this series, we are going to discuss all the question papers along with the answers and some kind of explanation related to that. Before we start, let me just introduce myself. My name is Vijay. I'm a patent agent working since 2005, and currently I'm a practitioner with my organization, Atlex Business Solutions, wherein we are involved into all the patent drafting as well as the prosecution and licensing related activities. So just to start with, as you know, paper one is more of objective kind of questions, and which is generally considered as easy one. But then there is always an opportunity to score really very high in paper one. So we'll see what kind of questions are being asked and how we can actually answer them rationally, as well as what is the logic actually for some of the answers actually in the first paper for 2018 examination. 2018 examination, paper one had three parts. Part A consisted of 30 multiple choice questions with one option correct of 2 marks each. Remember, in paper one, just you need to ensure that different parts have got different kind of questions, as well as there may be multiple answers or single answer correct, that you need to ensure that you are actually reading it correctly and then only moving on. So part one or part A consisted of 60 marks, 30 multiple choice questions. Each of the question had 2 marks each. Let us start with the first question. The first question in this exam was: the central government, if satisfied that it is necessary that a patent should be acquired from the patentee for a public purpose within the provision of the act, then a notification is published in. इसका मतलब ये है, central government can at any point of time acquire a patent from a patentee for the purpose of public, as in for the benefit of public. In that case, how is it done? It has to be done through a notification which is published in the options where all leading newspapers and journals, official gazette, on all of the above. So the correct answer for this is official gazette. This is as per section 102 of Indian Patent Act. As per this, the correct answer is official gazette. The second question is: choose the correct option from the following. Every application for a patent gets published under section 11A of the Act, except in cases where the application, every patent application that you file gets published except one kind of application. And the right answer for that actually is we are going to see here. The first option is in which secrecy direction is imposed under section 35 of the act. Agar secrecy direction imposed hota hai under section 35, that application is not actually published. So the first answer is a correct one, but then we have to choose the most correct answer. Then second is: the application has been abandoned under subsection 1 of section 9 of the act. It also doesn't get published. The third is: the application is withdrawn 3 months from the prior to the publication. So 15 months ke andar agar aap application withdraw karte ho, then also the application doesn't get published. So the correct answer in this case is all of the above. In case of request for examination of making patent application outside India, as per section 39 of the Act, the time frame to dispose such request by controller is. This question is related to foreign filing license, and in this case, we know that under section 39, if I have to file a patent application outside India, in that case, I need to seek a permission from the controller. This is applicable in two cases. One, I file a patent application in India, and within 6 weeks time, I file a foreign application. In that case, I need to go to the permission for the foreign license. As well as If I don't file an Indian application, I directly want to file a foreign application. In that case as well, the foreign filing license, this particular permission is required from the controller. So what is the timeline? The timeline for that to dispose the case from the controller. Remember that we are speaking about two separate timelines here. Applicant के end से within 6 weeks after filing of Indian application, आपको permission seek करना पड़ता है. But once you ask for the permission, controller has just 21 days, that is 3 weeks time, as per section 39. So the correct answer to this is within 21 days from the request actually. A patent awarded by the Patent Office of India is valid in Indian territory. Patent is a concept which is jurisdictional. Although while evaluating the novelty specifically, the novelty has to be checked globally. That's what we call absolute novelty. But the rights that you get are only for your territory, that is Indian territory only. So the correct answer is C. Now, one PCT application with US priority is filed on 19th of September 2009. And for filing the national phase application in India, the applicant need to file within a time period of, so PCT is 3-stage process. You file a US priority or Indian priority first. This is filed on 19/9/2009. Within 1 year, you are filing a PCT, and thereafter we have two separate timelines, 30 or 31 months, within which you have to file the patent application, national phase application. PCT is an international phase. National phase in individual country need to be filed within 30 or 31 months. India is a 31-month. National phase entry in India is allowed within 31 months. So 31 months calculated from 19th September 2009 turns out around 19th of April 2012. That's the correct answer for this. Herein, the next question is, a patent application applicant may file a patent infringement suit within the provision of the Patent Act only after publication, grant, priority date, or date of filing of a complete specification. The correct answer to this is grant of a patent application. Once the patent is granted, then only you can file your patent infringement suit. But remember that in case you win the case, the damages are applicable from the date of publication. Now, as per the next question is, as per the Patent Act 1970, the first compulsory license granted in India was or is related to. The correct answer to this is Natco Pharma on 9th March 2012. The compulsory license was given to a product, a buyer's product called Nexavar or Sorafenib. That's the only compulsory license till date Indian Patent Office has actually granted till 1st January 2022. The next question is, method of committing theft is not patentable in accordance to one of the sections of Patent Act 1970. Find out the relevant section from the following. Remember, section 3 is the most important section in the Indian Patent Act as far as the patent agent examination is concerned. There will be a lot of questions related to section 3. So here in method of committing theft is not patentable under section 3B of the Patent Act. Section 3B says anything which is contrary to public order or morality. So method of committing theft may be novel, but it is against the public morality, because that's a crime under the Indian Penal Code. So that way this particular invention is not patentable under section 3B. Next question, question number 9. As per the Indian Patent Act, the term of patent of edition filed on 13th April 2012, एक patent of edition है which has been filed on 13th April 2012, which got granted in 15 with regard to a complete application which was filed on 15th July 2008 and which was granted on 17th September 2011 is up to, and the in the bracket you would see that considering that neither one is revoked prior to the term of validity. If none of the patent is revoked before the priority term of validity, in that case, the term of a patent of addition is usually 20 years from the parent application, not from the patent of additions. Under section 55, the term of a patent of addition is always equal to the term of the original or parent application. Here in the parent application was filed on 15th July 2008 and it would get expired on 15th July 2028. Question number 10. An appeal shall not lie to the appellate board as per the Patent Act for the following option. Refusal of a patent application. Application is deemed to be abandoned under section 21. Decision of controller with respect to compulsory license or decision related to post-grant opposition under section 25(4) of the Indian Patent Act. Now, in this context, the right answer is section 21. Any application which is abandoned, and in that case, it cannot be appealed. For your information, appellate board has been dissolved recently, and we don't have the sections related to appellate board applicable now. But this is 2018 question paper, and it had this particular question. Now, the period for which an application for patent shall not be open to public in Patent Office Journal from date of filing or date of priority, whichever is earlier, and assuming there is no request for early publication. Normal publication, not early publication, normal publication happens in India in 18 months as per the Indian Patent Act. In fact, in most of the countries, including the PCT US, the patent application gets published after 18 months from the first filing date. Now, an Indian applicant has filed an ordinary patent application before Patent Office by filing a provisional on 12th May 2011, assuming there is no post dating. Now, choose the correct option. The applicant filed the complete specification on 12th August 2012, which is more than 1 year, but Form 4 में 11th May 2012 को 3 months का extension apply किया गया था. This is first option. Second option is the applicant filed complete specification on 12th May 2012. Third option is the applicant filed a petition under 138 of the prevailing rules and submitted the complete specification on 12th June 2012 basically. And the last option is none of them. Complete application is usually filed within 1 year time from the provisional. So the correct answer to this is the applicant filed complete specification on 12th May 2012. Question number 13. As per the Patent Act, the qualification required for a registered patent agent to work as a technical member of appellate board. Again, appellate board has been the IPAB has been dissolved. But now, in this case, the options given are master's degree in science with 8 years, function as a registered patent agent, or degree in engineering or technology, or master's in science with at least 10 years of functioning as a registered patent. The correct answer is the B actually for this. Next question, question number 14. As per Patent Act, Register of Patents shall contain, Register of Patents contain names and addresses of grantees, revocation of patent, notification of assignment, and transmissions of patents as well. All this information is included in the patent register. So the correct answer for this is D, all of the above. This is under section 67 of Indian Patent Act. Now, any person interested may make an application to controller for granting compulsory license in the as per the following grounds. Now there are multiple grounds given here, and we know there are multiple grounds for compulsory licensing, but the three major ground, and one of them is included here, is patented invention is not available to public at affordable price. The other two grounds that are required, that are applicable for compulsory license, are reasonable requirements of public are not met and the invention is not worked in India. So the compulsory license ke three grounds hai. One, the reasonable requirement is not fulfilled. Matlab, the kind of product that is required to fulfill the entire population is not fulfilled. Second, the invention is not available at a reasonably affordable price. Third is the invention is not worked in India. So the correct answer to this is question 15 is A. A researcher finds an idea on recycling of biodegradable plastic. How does he proceed for patenting his idea? Very basic question. When a client comes to us as a practitioner, many a times what happens is the client has already published that work in the scientific journal, and that's what the first option is. He needs to publish in scientific journal and has to wait for invitation from patent office. Patent office would never invite you to file a patent application. It is your duty to file a patent application before publication. Remember, if you file a patent application today, you can publish it tomorrow, but the reverse is not applicable. Now the second option, that is a correct option. He need to submit provisional specification and subsequently to file a complete specification before the Indian Patent Office. That's what the correct answer. Like the next question is, invention as per the Indian Patent Act incorporates industrial applicability, inventive step, also what we also call as a non obviousness, and the third one is a actual product or a process. All these things are included in the invention definition of an invention. Now identify from the following patented products for which compulsory license are available for export purpose, which is entitled for manufacture and export to any country having insufficient or no manufacturing capacity to address public health problems. So this question is specifically for public health problems and compulsory license. Therein, disaster management related device, pharmaceutical product, food products, but the correct answer to this is pharmaceutical products only. Question 19, when a patent completes its full term of 20 years within the provision of the act, patent is a kind of IP which is not renewed. Copyright, trademarks are renewed, design is once renewed, but patents are never renewed. So once its term is complete, then it is not renewed. As well as, remember, Indian Patent Act doesn't allow you to have any kind of patent term extension as well. Now, a seized patent due to non-payment of renewal fees, आपने renewal fees pay नहीं किया, may be restored by filing an application for restoration with prescribed fees as per the Patent Act, and the timeline is 18 months. As far as the timelines are concerned, class, every one of you need to remember all the timelines during the specifically the prosecution, that is from the filing till grant or even post grant maintenance. In these cases, you need to remember the timelines. There have been a lot of questions on the timelines specifically. Next question, another one for the timelines. The submission of proof of right to make an application for patent by virtue of an assignment as per the Patent Act shall be within a prescribed time period of 6 months. This is done under section 7.2 rule 10. How is it done? What is that proof of right? If you look at the form 1, there's a declaration by the inventor. That is actually a proof. Actually a proof of right to make an application for the patent, basically. So if you look at form 1, so and that has to be submitted within 6 months from the date of filing of the application. Now find out from the following which is not the ground for opposition for under section 25(1). Now herein we have got 4 options. The first one is the request for examination has not been filed by the applicant himself. Is this the ground for opposition? This is not the ground for opposition, because request for examination can be filed even by third party as well. That is allowed in under the Indian Patent Act. So the request for exam, so this is the right answer. All others are definitely the grounds for opposition. The complete what the second option, if you see, it speaks about the sufficiency of disclosure. The option C speaks about form 3 section 8. Option D is for wrongful obtaining. If you look at section 25(1), the first is the one which is not a ground for opposition. Now, international application as per the Patent Act means this is something which is about the multiple treaties that Indian Patent Office in India has got actually. So international patent application as per the Patent Act means there are the 4 options: WTO application, Hague Agreement, PCT, and the Budapest Treaty. Now, if you look at the correct answer is PCT. For Hague Agreement, it is for designs, not for patent application. And Budapest Treaty is for microorganisms, inventions related to microorganisms. Question number 24, discovery of a new galaxy is not patentable under section. Again, as I said, section 3 is very important. 3C(k)(d)(b). The correct answer to this is section 3C. Discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. Invention and discovery. Invention is something what we are creating basically. Discovery is something which was already there. We are just identifying it. So that discovery, so the galaxy was already there. Discovery is not patentable under section 3C. Now, definition of capable of industrial application in regard to invention as per the Patent Act means the invention is capable being made or used in an industry. Made, industry ने बनाया है या industry में use किया है. Or now look at the other 2 options. The invention is capable of being only manufactured. That's not the correct answer. The most correct answer, okay, that is also a correct answer, but the most correct answer in this case is A. And that's and if you look at C, the invention is capable of being sold by an industry. That may also be a correct answer, but the most correct answer in this case is A. Now under section 2(1) AC. Appeal may be filed against decision of controllers of the patent under the Patent Act before IPAB. Again, repeating this, IPAB has been dissolved now. It's not applicable. This is a 2018 question paper, and you had these questions at that point of time. Now, an interesting question, which is again related to a practitioner. As a practitioner, I come across this. There are multiple applicants who are filing a patent in India. Patent is granted, and now there is a doubt who really owns the rights and how much rights do they have. As a patent agent, what will be your clarification to your client? When a client comes to us, that point of time, if you compare it with the research paper, that point of time, we have this concept called corresponding author in the research paper. That's what second option, if you look at. First name holder in the patent application shall get major share. That's not correct. In case of patent, each and every inventor or applicant would have the equal right, provided they are not bound by any contract. So if you are filing a patent application, 3 applicants, and they are actually having a separate contract that each one of them, let us say, would own 40, 40, 20. In that case, this is not applicable. But If they do not have any contract, then in that case, each of them would get 1/3 of the share. The other option, sharing shall be based on alphabetical order, no way, or date of birth, seniority, no way. It doesn't work that way. Now, question 28, a patent shall be deemed to be revoked in public interest by the central government. Again, remember, whatever decisions of the central government are there, they are published in official gazette only. So again, for this as well, the answer is official gazette and not in the newspaper. And this is under section 66. Now, question 29. Article sold by a manufacturer with engraved with the word patent falsely. मेरे पास patent नहीं है, फिर भी मैं कोई manufacture करता हूँ and उसको मैं patented ऐसे लिखता हूँ. So that's what is called an engraving, or the term is also patent marking. In that case, the punishment under Indian Patent Act, the options are imprisonment for 2 years, fine which may extend to 1 lakh rupees, imprisonment of 1 year, and fine of rupees 50,000. यहाँ पे मुझे आंसर नहीं पता है honestly, but then one thing for sure I know that A, C, D are covering imprisonment, and let me tell you, IP rights we know that are the civil rights, or the civil rights basically. So therein the answer would be, and in case of civil rights or the civil remedies, the answer is always the damages in terms of money. So fine hoga up to 1 lakh rupees. That's what the correct answer is. Now, last question in part A. An application is filed. Applicant has filed an international application on 5th July 2012. जिसका provisional was filed on 8th August 2011, and again national phase filing on 10th September 2013. Grant hota hai 16 mein. What is the term of the said patent application, considering the application patent is not revoked? ये बड़ा interesting है. Reason being, if you look at the language herein, the kind of language, exact wording अगर आप देखते हो, then 5th July 2012 को provisional file किया गया था and 8th August को PCT file किया. The entire question is silent about complete application filing. Now in that case, and PCT application file, PCT application से उसने national phase entry किया, उसके बाद वो grant हुआ है. Provisional से complete नहीं है इस case में. Now in this case, actually the actual filing date is 5th July 2012 for international application. So the term of that application is 5th July 2032 actually. Now this was all about part 1. Part B is interesting herein, and it has 10 questions of 1 mark each. For each question, you have to evaluate. There are 2 statements given. And like 1 and 2, you have to check statement 1 is true or false. Statement 2 is true or false. Agar statement 1 is true and 2 is false, your answer is A. If statement 1 is false, 2 is true, your answer is B. Both the statements are false, your answer is C, and both are true, the answer is D. Now, the first question here is amendment of an application for patent or complete specification or any document relating thereto at any time before or after the grant as per the provision of the Patent Act shall be made by way of disclaimer, correction, explanation, and incorporation of actual fact. This is the first statement. The second statement is shall be allowed though it describes matter not in substance or shown in the specification before the amendment. The correct answer to this is statement 1 is true, second statement 2 is false, because Indian Patent Act doesn't allow you to add any data which is not there in the specification when you had file date. So the correct answer is statement 1 is true and 2 is false. The correct answer is A. Question 32. Mr. Rao, a researcher from a reputed institute of Bangalore, filed one ordinary patent application before patent office, though he has published the same in a journal 5 years back. सेम केस 5 साल पहले जर्नल में पब्लिश कर दिया, अभी आपने पेटेंट एप्लीकेशन फाइल कर दिया. He was so back before the filing date of the application, as he was confident regarding the fact that author of the journal and patent application being same, and his application shall not be refused. This is wrong, because although the publication is all yours, आपने खुद ने publish किया है, still your application would be refused, because whatever is in public domain would act as a prior art for you. It would destroy the novelty, and that is what is false. But the second statement is, Mr. Rao, researcher, has filed one ordinary patent application before patent office. He has published the same subject matter in an international journal after the date of filing. So the sequence always is file patent first and then publish. That's what statement 2 says. Statement 1 is false, 2 is true, and the correct answer is for you B. Question 33. Application to the controller for review of his own decision as per the what we call as a review petition, as per the Patent Act, within the provision of prevailing patent rules, shall be made in Form 24 within 1 month from date of communication of such decision to the applicant, or within such further period not exceeding 1 month thereafter, as the controller may, on a request made in Form 4, stating all the grounds on which review is sought. The second statement is application to the controller for the review of his own decision as the Patent Act with the provision. ये पूरा part same आ रहा है, but within 1 की जगह within 6 months time आ रहा है. Actual answer to this is within 1 month. Form 24 you have to file within 1 month, and not within, I would say, the 6 months as per the statement 2. So the correct answer is statement 1 is true, 2 is false, and the correct answer is A. Question 34. Company X having an office at US initially filed an application at USPTO, and after 6 months from the US application, the company has done some modification and filed another application at USPTO. There are 2 patent applications at USPTO. Within 12 months, company what it does is it files an Indian application through convention application, and claiming the priority of those 2 earlier US application. Now, in that case, there are 2 statements. Company X is allowed only to claim pertaining to earlier priority, and therefore controller refused it. Second, company X is allowed to claim both the priority, and the priority date of the first application is the date on which it was first disclosed. The statement 1 is false, 2 is true. You're allowed to take multiple priorities, but आपको जब कन्वेंशन एप्लीकेशन या पीसीटी एप्लीकेशन फाइल करना है, दैट हैज टू बी फाइल्ड विद इन 12 मंथ्स फ्रॉम द फर्स्ट फाइलिंग डेट. फर्स्ट जो एप्लीकेशन है उससे उसके बाद विद इन 12 मंथ्स, like what we call as multiple priorities basically, and you can have any number of priorities within 1 year, and you can club them basically. Now, as per the Patent Act, claim shall relate to a single invention or relate to a group of invention linked so as to form a single inventive concept. What we call it as a unity of invention, and this includes both, as in single invention or multiple inventions, so that they're linked together to form a single inventive concept. Both the statements are true, and the correct answer is D in this case. Now, for any proceedings before the controller as per the Patent Act, he shall have the power of a civil court while trying a suit under Code of Civil Procedure 1908. We are speaking about the civil procedure basically here. In respect to the following matters, what are they allowed to do? Summoning of any person and receiving evidence on affidavit. This is first option. Second option is power for setting aside order passed ex parte on application made within the prescribed time and prescribed manner. Both the statements are true. Controller has powers of civil court to take the affidavits. We provide these affidavits many a times wherever required by the applicants, as well as can set aside the order which was passed on application made within the prescribed time and manner. Question 37. Applicant X and Y file patent application jointly. The application shall be examined on filing requests for examination within the prescribed time as per the provision of the act by X or Y. Now, this is the first statement. Second statement is applicant X and applicant Y file patent application jointly before Indian Patent Office. The examination shall be examined, the application shall be examined on filing RFE, request for examination, within the prescribed time as per the provision of the act by any other interested person, Z, as well. Now, remember, request for examination can be filed by third parties as well, those who are interested in the invention, not only the applicant but also the third party. So both the statements are correct. Question 38. As per the Patent Act 1970, if applicant mentions a biological material, and if such material is not available to the public, then application shall be completed by depositing the material to IDA, International Depository Authority, under Budapest Treaty, not later than the date of filing of patent application in India, and reference thereof shall be made in the specification within 3 months of the time actually. This is the first statement. Second statement is he does not have to deposit the biological material. First statement is the correct one. First statement is the correct one. Second statement is false. The correct answer to this is A. Statement 1 is true. When you file a patent application, if there is a biological material like microorganism, that's what we discussed under Budapest Treaty, you have to submit that material to IDA, and you have to mention within 3 months time it in the patent application. Now, question 39, as per the provision of Patent Act, a patentee may at any time after grant offer to surrender the patent. First option. The second option is the patentee may offer to surrender only after 3 years. Now, herein the correct answer is any time after the grant. Is the true? A. Statement 1 is true. Statement 2 is false. Now, question number 40. As per the provision of Patent Act, a patent of addition shall be granted before the date of grant of a patent for the main invention. That is wrong. Patent of addition तभी grant होता है जब main invention, parent invention grant होता है. So the first statement is false. Second statement, as per the provision of the Patent Act, the patent of addition shall not be refused on the ground that invention claimed in complete specification does not involve any inventive step with regard to main invention. Matlab, main invention ke, so you have a main invention, you have filed a patent of addition. Now, patent of addition ke liye, main invention is already in public domain. It's published already. Would it act as a prior art? The answer is no, it won't act as a prior art because the priority usi ka le raha. The second statement is true, first statement is false. So this is about part B. Part C had 10 questions for 30 marks, and yahan pe at least 2 options are correct. Multiple choice here, but remember, at least 2 options are correct. You have 10 questions in this. First question, a national or regional patent office grants a patent. Following are the regional patent offices which are operational. The options are ARIPO, WIPO, EPO, and EAPO. the correct answer for this is A, C, and D. ARIPO is Africa Regional IPO. EPO is a European, and EAPO Eurasian countries, Russia and like those countries which were part of USSR. EAPO, Eurasian Patent Office. The correct answer to this is A, C, D. ये तीनों आपने लिखने हैं, then only you will be getting 3 marks. If any non-registered patent agent practices before patent office, he shall be punishable within provision of the Patent Act with 1 lakh for first offense and 5 lakh for second offense or subsequent offenses. Patent agent जो नहीं है, if he or she practices in patent office as a patent agent, in that case, the correct answer is C and D. 1 lakh rupees for first offense, and further it would be 5 lakh rupees for second offense. Now India is a member of this question is something which is, I would say, if it had been for 1 mark, then the correct option would have been C. PCT and Paris Convention, both of them India is actually a member. But then since it is, herein you don't have to identify the most correct answer, you have to identify all correct answers. In that case, the correct answer to this is PCT, Paris Convention, both A and B. So A, B, C are the correct options actually. So PCT and Paris Convention are the 2 routes through which foreign filing is done. So Paris Convention, a treaty was done long back in 1883 and PCT in 1970. So question 44. Applicant has received a direction from the controller under section 16. Section 16 speaks about divisional applications. What are the options for the applicant? What can an applicant do? He may file a divisional, that's the correct thing. He may ask an oral hearing to convince the controller that the invention comes under single inventive concept. And C is he may forego second invention. D is he may file divisional application for the second invention after the grant of first one. Now, after the grant of first one is applicable in case of patent of addition, but not in case of divisional application. Divisional application need to be filed before the grant of the parent invention or the main invention. So the correct answer is A, B, C. The applicant has the right to file divisional before grant, or he can ask for an oral hearing to show that, oh no, it's a single inventive concept. So to show the controller that there is a unity of invention, or he can leave that second invention as it is. Question 45, application for a patent for an invention may be made by, very simple question. The answer under section 6, person entitled to apply, true and first inventor, assignee, and legal representative of the true and first inventor. ये 3 cases में आपका person entitled to apply a invention. Now, this question is something which has been discussed in a very famous case law as well, and many times students come to us and ask, sir, हमें सारे के सारे sections याद रखने की जरूरत है क्या? This question I would have if you read the question, you would realize it covers almost 9 different sections. How would I remember 9 different sections? Let us try to read the question. Which of the following sections are appealable against the decision, order, or direction of the controller under the provision of act? कौन से sections हैं which are appealable? Now, herein we know that most of the sections which are mentioned herein are appealable. Under section 117A, appeals, you have a pool of sections which can be appealed basically, but there is one section, that is 21, which is about abandonment of an application. There was a famous case in 2009, long back, I would say, wherein Ericsson versus Union of India, wherein it so section 46, which of the following sections are appealable against the decision, order or direction of the controller? The right answer to this is A, C, D. Section 21 is not appealable, which is about abandonment. There was a famous case by Ericsson versus Union of India in 2009, actually, which was about was Section 21 applicability and its appeal, actually. So it is not appealable. So this case is also very important case, actually. But then under Section 117A appeals, this Section 21 is not included in that. And that's the reason I have taken it in a reverse way. Section 21 definitely is a wrong answer. I have put it other three, actually. Which of the following are not patentable as per the provision of Indian Patent Act? A surgical instrument, a computer program, or discovery of any living thing, and a clock having 10 hours and each hour divided into 100 minutes. Computer program per se, not patentable. Discovery of any living thing, not patentable. A clock having 10 hours and each hour divided into 100 minutes against the natural laws, not patentable. Surgical instrument. Now, someone had asked me this, surgical instrument, is it patentable or not? Surgical methods are not patentable. Surgical instruments definitely are patentable. Computer program under 3K, not patentable. Discovery, not patentable under 3C. And frivolous invention is something which is, the clock is not patentable, basically. Question 48, there are various modes for revocation within the provision of Patent Act. What are those modes? Revocation by appellate board, which is not active now. Revocation by the controller and by the central government. Now, question 49, applicant A has been granted a patent as per the Patent Act. The exclusive rights would be conferred upon A to prevent third parties. What are the rights for a patentee, basically? From making, selling, importing, or exporting, that's not allowed. So A, B, C are the right answer. Last question. A patent of a reputed company D in steel industry has been seized due to non-payment of fees. D applies for restoration. This is about restoration of patent. And suddenly another company of the same industry opposes, a steel industry opposes the request for restoration. What are the grounds for opposing the restoration? Here in only there are two grounds: that the failure to pay renewal fee was not unintentional, and the second ground is there has been undue delay in making the application. If it is not worked within the territory of India, आपको compulsory licensing के लिए वो ground है, not for this. And even C is for compulsory licensing, not for the opposition for the what you call restoration of the patent. So the correct answer in this case is B and D. So this is for 2018 question paper 1. Actually, the answers and a bit of explanations. I would have another round of discussion with all of you when we would discuss next question paper for the next year very soon.